An interesting and important turn of events has happened in the Daybell case. We were only a month away from the start of trial for Lori and Chad Daybell. It's been a long 3 years to get here, but Judge Boyce decided on Thursday, March 2nd, to sever the cases between Lori and Chad. Lori's been in jail for the last 3 years, with Chad not far behind. Since the beginning, Lori didn't waive her right to a speedy trial, but Chad did. There was an emergency hearing on February 27th, and during that hearing was a new discovery of a DNA report. New DNA was said to be found and tested, and said that it was found at a crime scene. We don't know, specifics weren't made publicly. So let's dive into what happened in court and what's happening moving forward. So now, let's get into it. Judge Boyce made the decision to sever the cases on March 2nd, something that John Pryor, Chad's attorney, has been trying to do over and over again. It's definitely a win, in my opinion, for John Pryor and Chad. And that hearing on the 2nd of March was a continuation of a hearing that happened just a few days before that, on February 27th. It was regarding this DNA evidence which was found at a crime scene. Lori was at the court hearing in person while Chad attended on Zoom, and Chad's attorney also attended via Zoom. And the prosecution were all in court along with Lori's attorney, Jim Archibald, but the other attorney, John Thomas, was also on Zoom. Now, one of my last updates, I talked about a hearing where this DNA was tested and they were discussing it. I talked about how testing was done, but the results weren't back yet, and John Pryor made a lengthy, as he usually does, argument. Now, John Pryor argued that he needed more time to review the results and have his own expert to look at it once it was completed, but that it would be impossible to get it done before the trial on April 3rd. So John Pryor argued how crucial it was for Chad to have a fair trial. He said, "That evidence provides, at least from my perspective, an explanation potentially of where Mr. Daybell and I are going to go in this particular case. I need to have an opportunity to test that evidence." Now, he also said he needed 60 days minimum from when he gets this evidence and technical data from the state. He said that this could have a profound impact on the case, and that it's a significant piece of information, and from the sounds of it, whatever it is quite the discovery. He said, "A piece of information that would have a profound impact on how this case proceeds and how the defense and the state presents this case." He said he has a right to test brand new DNA evidence and a right to test and question the most recent report that came in on Tuesday, February 28th, and that he hadn't had a chance to go over this report. John's demeanor was a little bit different at this hearing. Usually we hear John, he's quite fired up and he goes on and on and on. I didn't hear that this go around. It was an hour and a half long of a hearing and he was quite subdued, getting a little bit riled up at the end, but it makes me quite curious as to what these findings are. Let me know what you think. And John made a statement which was kind of humorous. He said, "I'm not going to pick on the state to everybody's surprise." I think John's well aware of what our thoughts about him. I mean, it's been a few years and, well, we like to take jabs at John sometimes. But I will say he did make some very valid points at this hearing. Now, Lori's lawyer, Jim Archibald, agreed with John and said that if he was in John's shoes, he'd do the same thing, asking for more time. But he isn't, because Lori didn't waive her right to a speedy trial. He said, "If my client waived her speedy trial, I would also be asking for extra time, but since she has held that right and held it close to her, I have to respect that constitutional autonomy that she has." Now, he said that he agrees that the blame is on the state and that they are either playing cute, his words, or playing ignorant, and also he said it's pretty ridiculous and disappointing how the state handled the situation. His disappointment was easily understood and conveyed in that courtroom. You could hear it in his voice and even in John's, really. He said that the state has been sitting on this info and that there are interviews from FBI back in 2020, and he's just questioning, like, why is he getting it now? He said he's just really disappointed at the prosecution. What are your thoughts about this? Because I am a bit surprised by this, but I wonder what the angle is from the state's point of view. Now, the state had their chance to argue, and the state said that there was a massive amount of discovery in the last 3 years, and the bulk was turned over, and the state went back through and didn't want to miss anything and found some new information. They said that items were located that they didn't realize that the defense defense has. They argued that there are multiple agencies as well and voluminous discovery. They said that the state is trying to do their due diligence. Now, the judge intervenes, Judge Boyce, and talks about this case and says, this is a capital charge case. These are capital charges, and asked, is the defense not entitled to all of it, not the bulk? He said they just don't get the bulk or the majority, they get all of it. And with the latest disclosure, the judge said that he has is that he gave a deadline prior to February 27th, not the day of, and although it's a day late, he says it's still a day late. And he said that the new filing of this discovery was received on the 27th at 4:03 p.m., and he said it's late. He knows how things can get hectic, and since this is a capital case, he says, and voluminous discovery, it's extremely concerning for the court. Now, Lindsay Blake, who's part of the prosecution, explains that it was the state's interpretation that the deadline was by the 27th and believed that was the day it was due, but the judge reads out loud. He says all discovery before February 27th. The state also talked about the DNA evidence and said this DNA was located with the other testing, and the evidence located was very early on. But this consumptive testing couldn't take place because Lori's stay in the case. Remember, she was deemed incompetent. So this testing was sent out east, they said, and that they had to wait to get it back, which was in November, and then the state lab finished the testing, and at that time the evidence was located by the state lab. It wasn't believed to have any value, they said, but they collected the evidence and they had to wait for an agreement on the testing, and in January they did. And the state said they learned about this newfound evidence just before defense counsel learned of it. Lindsay Blake also reiterated, and we heard this before, that the lab was not confident that there would be any evidentiary value to it. And the state didn't believe that there was either. However, they located a lab and they did additional testing, and they reached out to both Lori's lawyers and Chad's, and John Pryor agreed to move forward, get this tested, and in court they said that Jim Archibald just didn't respond. And once this was completed, they said the report was turned over immediately to the defense. Now the judge said, wait a minute, he's confused because he says that it appears that there is something there. There is DNA evidence. It came directly from the crime scene. He says it's indicative of unknown persons that can further be identified by further testing. And also there's probably going to be that genealogical component to it, right? Trying to figure out who owns that DNA. The judge asked, wouldn't it be better in this case to sever? Lindsay Blake says no. She said one of the reasons is because then one party gains a tactical advantage if one of the parties go first, among other reasons. Now, according to Judge Boyce, he felt he had no choice but to sever these cases because the evidence wasn't passed on to the state in a timely manner, and Lori refused to waive her right to a speedy trial, and he's cognizant of Lori's rights, and all these put together. And I believe that it did take some time for Judge Boyce to come to this conclusion. He did weigh on it, in my opinion. He says, I have to balance these rights of these defendants in this case. He said, severance is the only option I see. And severance has come up over and over again, and there were so many important points to not sever this case in the past. It's expensive, it's redundant, meaning the same evidence will be presented, and the family of the victims have to go through this not once but twice, which takes a toll, plus double the travel. Now for John Pryor, he's mostly likely celebrating, in my opinion. He's wanted Chad as far away as possible from Lori Daybell, and even in recent hearings where Chad and Lori were both present in the courtroom, we heard from Nate Eaton of East Idaho News, who said that Lori would stare at Chad and Chad wouldn't even look Lori's way. So there was already a little trouble in paradise for them. I do wonder if they stopped communicating from their portals. Remember how they said they could communicate that way? And I think it was even Lori who would go into the closet and that kind of thing. I call it the portal potty. So now Chad's trial has been vacated. The April 3rd date is no longer, and it will have to be rescheduled. John Pryor also complained a lot about not being ready for trial and needing more time to prepare, so he gets this wish granted. Now, Judge Boyce also said that Chad's trial could be pushed out as far as 6 months from now, which would take us to September, the month that both J.J. Vallow and Tylee Ryan, Lori's children, were murdered, and Chad's wife, Tammy Daybell, was murdered the month after in October. But even the judge talked about it could be at the end of 2023, and there were already concessions made by moving the trial from January to April, and then how Ada County is very busy with their court, with the hearings and trials. The prosecution suggested moving both Lori and Chad's day to, May or June, but the judge said the length of the delay, if I were to continue this, it would be up to Ada County, and I don't believe it could be a short delay. It would have to be more than 6 months additionally. Now, Lori's trial will begin a month from now on April 3rd. Are you surprised that she stuck to her guns and didn't waive her right to speedy trial? That she didn't want to match her fifth husband and lover, Chad Daybell? What do you think? You gotta wonder what they have on this new DNA. And according to courts, it would take up to 6 weeks to find out and test. Lori has only 4 weeks to go. So I wonder what she's thinking. Maybe this is a blessing for her on this. But don't forget, after this trial is over, dear old Lori, she gets to jump from one boiling pot to another. She'll have to face her charges in the murder case of her fourth husband, Charles Vallow. And just so we remember the victims, J.J. Vallow was duct taped and bound and buried in Chad Daybell's yard. Poor Tylee was burned and dismembered and also buried in Chad's yard. And Tammy Daybell, Chad's wife at the time, went to bed with a bad cough, which I think is a load of garbage, and didn't wake up. She had an attempt on her life before this successful time. And poor Charles Vallow got shot when he went to pick up JJ to take him to school. And at this time, JJ and Tylee are still not laid to rest. So all these events were conniving, they were thought out, and they were executed. So together or not, the show must go on. And whenever there's Lori Vallow Daybell, we know there's a show. I wonder how many smirks and smiles and pageantry that Lori Vallow Daybell is going to display. We'll never know because we don't get to, at this point, see what's going on. So what does this mean for Lori? Do you think this will be an advantage for Chad with Lori going first? Let me know below. Check out the most important videos on the case here, and you can also check out all my videos on the Lori Daybell case, which I think is about 150 right here. Thank you so much for watching. We'll see you in the next video.